Hi, this is Nicole Scheidel and our weekly look at life issues in healthcare. Like many of you this week, I was really shocked by the recent story about a veteran being offered assisted suicide for his PTSD. And today I'm joined by Member of Parliament Michael Cooper to talk about the expansion of euthanasia in Canada. So thank you so much for being here with me today.
Good to be with you.
So you've been very involved in this issue. During the committee hearings on Bill C7, you participated in an important press conference with physicians who were sounding the alarm about euthanasia. And you're now on the committee that is tasked with doing a review of the legislation, including the current proposed expansion to mental illness as a sole condition. What have you been hearing from physicians in terms of their concerns with the expansion of euthanasia in Canada?
Our committee has heard significant concerns specifically about expanding MAiD in cases where mental illness is the sole underlying condition. One of the biggest issues in that regard is that there is no ability to predict irremediability. In other words, it's not possible to predict whether someone can get better. Indeed, the government's own expert panel said it is difficult, if not impossible, to predict irremediability. And that's the government's own panel. And in the face of that, the government has decided, nonetheless, the Liberals, to recklessly move ahead with such an expansion, even though, if you can't predict irremediability, what that means is that persons suffering from mental illness could potentially get better and have years to live a healthy and productive life, and have that opportunity taken away, their lives prematurely ended. So it is a very dangerous expansion, and all of the evidence indicates that instead of moving full steam ahead, what the government should be doing is putting a pause on such an expansion. But that's not going to happen, because for David Lametti and the Liberals, this is about ideology first.
I was really struck when Bill C7 was working its way through the legislative process that all the safeguards were getting removed. The reflection period was removed. The need for independent witnesses was removed. So given your background, why is removing those safeguards problematic from a legal standpoint?
Well, first of all, Bill C7 should never have been introduced in the first place. Bill C7 was introduced in response to the Cruchon decision in Quebec, which removed or struck down the criterion that death must be reasonably foreseeable in order to qualify for MAiD. That arguably is the most important safeguard. It was a decision of one lower court judge. It is the responsibility of the Attorney General to defend the laws of the land. The Attorney General should have, and I believe had a responsibility in the face of that decision, to have appealed the decision. But instead, immediately, David Lametti accepted the decision and introduced Bill C7. But as bad as that was, and in the face of significant opposition from virtually every disabilities rights organization, and even drawing international rebuke with the special rapporteur on the rights of persons with disabilities expressing a concern that it might violate international law, the government moved ahead. And the reason there was such concern is when you remove death being reasonably foreseeable, what it means is that for persons who are suffering, or who aren't suffering, but persons who have degenerative disabilities, that they could qualify for no other reason that they are disabled. In other words, what this means is it means the promotion of ableism in our society, which is very, very dangerous. But be that as it may, and as bad as that was for the Liberals to introduce the bill instead of appealing the Cruchon decision, as you noted in your question, the bill went a lot further than that. It removed other safeguards that were not part of the scope of the Cruchon decision. So the government just decided we're going to remove those safeguards, including the requirement that there be 2 witnesses upon someone making a request for MAiD. Now, only 1 witness is required. When you execute a will, you need 2 witnesses. But when you're making a request to end your life, you need 1. It simply doesn't make sense. And with respect to the other common sense safeguards that were removed, including being able to make an advance request in certain instances, this again opens the door to coercion, to persons who may end up having MAiD, even though in the end they may not have wanted it. So there are very serious issues at hand. And as a result of the removal of these safeguards, we are seeing more and more cases of abuse and non-compliance.
Yeah, I'm just wondering what the motivation or the thinking would be behind removing safeguards. So, for example, this week we heard about the veteran who was offered assisted suicide for his PTSD, even though he hadn't requested it. He never asked about it. He never inquired. It was completely on the volition or the instigation of the service agent from Veterans Affairs. So why would the government not put in a safeguard that those conversations can only be patient initiated? What is their thinking behind that that's not an acceptable safeguard?
You'd have to ask the government, and specifically David Lametti, that question. I'd be interested in his answer, but I completely agree with you. It should be patient initiated. Otherwise, you open the door, as we have seen, to instances where there is coercion and pressure, even if it's well intentioned. It could put someone who is in a vulnerable position to make a decision that they otherwise would not have made. And one of the safeguards that was removed in Bill C-7 is the 10-day reflection period. So now MAiD could be carried out rapidly, almost immediately. And so, again, this is a real cause for concern. And I do want to note and stress that that case involving a veteran who was suffering from PTSD is not an isolated incident. We have seen many other cases.
So just on that note, and thinking about in March when the law takes effect and individuals who have mental illness as their sole condition are then also can also have euthanasia. What's going to happen then? Like, what are you thinking is going to happen?
What is going to happen is that people who otherwise should not are going to have their lives ended. People who really don't qualify because it's not possible to predict irremediability. And irremediability is one of the key eligibility criterion in the criminal code. And so that is the consequence of the government moving ahead with this.
And do you think there's a lack of coherence too if we have suicide assistance on one hand and suicide prevention on the other? Like, how do we as a country make that coherent in our thought processes of the way we approach people?
Yeah, well, it's an important point. And when you remove the reasonable foreseeability of death, and then you open the door to where mental illness is the sole underlying condition, you're moving significantly away from what this procedure is called medical assistance in dying to medically assisted death or state-facilitated suicide.
And do you think that having an acronym like MAiD desensitizes Canadians to the reality of what's happening?
I think it does. And again, as I noted, that as this regime becomes more and more expansive, arguably it will be the most permissive regime in the world, or if not, on par with that of the Netherlands, depending on how you look at different eligibility criteria and different parameters. But absolutely, we are headed down a very dangerous road. We're well on our way down that road with very little to no study or consultation. In the case of mental illness, I wanted to note that when I mentioned no study or consultation, and how we got to where we produced, it did not include opening or expanding MAiD in cases of mental illness. There were those radical activists, I would characterize them, who said that it should be expanded in cases of sole mental illness. David LaMetti at the time said, no, there are inherent risks involved. It requires at the very least more study. He was precisely right when he said that. What did he then do? Well, the bill went over to the Senate. At the 11th hour, there was a Senate amendment introduced by Senator Kutcher of Nova Scotia that imposed a sunset clause on excluding mental illness from being eligible, or cases of sole mental illness being eligible for MAiD effective March of 23 next year. LaMetti accepted that amendment. No study, no consultation, and now in the face of evidence from experts that says it's not even possible to predict irremediability. If that isn't reckless, I don't know what is.
Well, okay, so we're here now. Can anything be done in Parliament specifically now that Bill C7's passed? And or what recourse do parliamentarians have to try to protect vulnerable Canadians from premature deaths that are often the result of coercion or poverty or just plain abandonment?
Yeah, I wish I had a good answer to that, because the government has the votes, and David LaMetti and Justin Trudeau have made it very clear the direction that they want to move ahead in. So we, as Conservatives on the Special Joint Committee, called on the government to put a pause on the expansion of MAiD in cases of sole mental illness. But realistically, that isn't going to happen. So ultimately, what will be required is Canadians recognize, and based upon the direction that the expert panel is moving in, I expect that the majority, not the expert panel, the Special Joint Committee that I'm on, the recommendations of the Special Joint Committee of the majority of members will be to further expand MAiD to include instances of mature minors, further expansion of advanced directives, and so on. And I would expect that the government, following any such recommendations from the majority of our Special Joint Committee, will proceed with legislation.
So we're kind of in a tough situation. What advice do you have for ordinary Canadians who want to advocate for those in their lives that are at risk for euthanasia? They may be suffering from depression or trauma. How can you see that we could create more hope instead of just having these deadly shortcuts?
What's required is for Canadians to speak up, for Canadians to be vigilant about what may be happening to a family member or a neighbor who's vulnerable, who may be pressured or in one of those situations, like we have seen, where they're being encouraged to have MAiD and to sound the alarm, because the more cases that are documented, and I think the cases that have been publicized are merely scratching the surface of what is actually happening right across Canada. That is what is required in order, I believe, for the broader public to see that this is not just about having a choice. I think a lot of people look at it and saying, well, if I'm elderly and my death is reasonably foreseeable and I'm suffering intolerably, I want to have a choice to end my life just a little sooner to end the suffering. Well, that may be what they want, but that isn't what we have in terms of the medical assistance of dying regime in Canada today. And it also doesn't take into account the fact that it's not just about a person's individual choice. There are vulnerable groups of Canadians, vulnerable persons who are at risk. And that was something that the Supreme Court recognized in the Carter decision that led to the expansion of MAiD in the first place.
Okay, so thank you so much for being here with me today. One of the small things that we're doing is we've started a petition for no soldier euthanasia. So it's really asking the Veterans Affairs Minister to make it a requirement of Veterans Affairs staff that they do not initiate discussions on euthanasia, that it's only patient-initiated discussions. So that's our one small point of trying to change the system a little bit. And thank you so much for being here with me today to discuss this issue.
Thank you.